Welcome to the McNees Intellectual Property Podcast Series. In this video podcast, attorney Emily Doan reviews two intellectual property cases to be decided by the United States Supreme Court. Ms. Doan practices in the intellectual property and esports practice groups at McNees.
It is not every day or even every term that the United States Supreme Court agrees to hear cases affecting trademark or copyright law. Today I am going to summarize two such cases the Supreme Court has agreed to take and what our clients can take away from each case as we await the court's decisions. In the first case, Fourth Estate versus WallStreet.com, the Supreme Court will resolve a circuit split over when a copyright is registered for purposes of filing a copyright infringement lawsuit. Under the Copyright Act of 1976, a plaintiff cannot bring a copyright infringement lawsuit until registration has been made. Based on this language, two approaches have developed to determine when a work is registered. Under the application approach, a copyright owner can file a copyright infringement lawsuit after the Copyright Office receives a completed application and the owner pays the required fee and deposits the work. Under the competing registration approach, a copyright owner can only file a copyright infringement lawsuit once the Copyright Office either approves or rejects the application. Circuits following the application approach believe the Copyright Act is ambiguous as to what is meant by registration, and therefore look to legislative history to discern the statute's purpose. Followers of this approach believe the application approach best effectuates Congress's goal to remove the Copyright Act of 1909's administrative hurdles to copyright protection. Circuits following the registration approach see no ambiguity in the statutory definition of registration and argue that the plain meaning of the statute requires the Copyright Office to act on the application before a plaintiff can file a copyright infringement lawsuit. Because the Copyright Office takes anywhere from 6 to 15 months to issue registrations, resolving this circuit split will provide better guidance on the timing of filing a copyright infringement lawsuit. Copyright owners should file copyright applications early to avoid any waiting period before filing a copyright infringement lawsuit and to take advantage of the Copyright Act's statutory damages and attorney's fees provisions for a work registered either within 3 months of publication or prior to its infringement. In the second case, Mission Product versus Tempnology, the Supreme Court will resolve a circuit split over what happens to a trademark license when the licensor declares bankruptcy. Under bankruptcy law, a debtor has the option to reject certain contracts to alleviate itself of financial obligations. The Bankruptcy Code has carved out certain contracts from this general rule, including contracts involving trade secrets, patents, and copyrights. Deliberately omitted from the list of carve-outs are trademarks, which has led to a circuit split in how to deal with a trademark license that has been rejected by the bankrupt licensor. Some circuits have held that the trademark license survives rejection so that the licensee may continue to use the trademark even when the licensor has no further obligations under the agreement. Other circuits go further, holding that not even the trademark license survives rejection, because allowing the licensee's rights to continue under the rejected agreement is contrary to absolving the licensor from its primary obligation to exercise quality control over the licensing of its trademarks. Trademark licensing agreements come with risks and rewards for both the licensor and licensee. Before entering into a trademark licensing agreement, it is crucial to understand the solvency of the contracting parties and develop a plan B should the agreement terminate or the contracting parties lose this important source of licensing revenue or brand recognition. McNees has a team of experienced copyright and trademark attorneys and litigators who are available to counsel business owners about intellectual property protection and licensing agreements. We will report on the outcomes of these cases and continue to monitor other developments in intellectual property law. To To learn more, please contact the McNees Intellectual Property Group.